We've mentioned several times the question of the advantages of worldwide enforcement. One of the things that you see here on the left of the screen is a world map with most of the countries of the world in dark blue. Those are the countries that are signatory to the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards. The yellow countries have not yet signed on, but as you can see, there aren't a lot of them. The New York Convention really does two things. What's most talked about is the obligation to enforce awards as if they were local court judgments. So if you have an arbitration award that's issued from a seat in Singapore, you can take that arbitration award to any of the dark blue countries and get it enforced. Similarly, if you have an arbitration that's seated in Mexico, you can take it to any of the dark blue countries and get it enforced. And it doesn't need to be the country in which your counterparty is physically located or it has its principal place of business, as long as you can find assets of the counterparty. So as an example, I once had an arbitral award against a Central European state, and that Central European state was unwilling to enforce the award within its own jurisdiction, but we found assets of that Central European state in 7 other jurisdictions where we were able to pursue enforcement, and ultimately the Central European state settled and paid the amount. The other piece of the New York Convention, which receives less publicity but is equally important, is all of the signatories to the New York Convention have agreed to have accepted an obligation to stay litigation in their jurisdiction if an arbitration award exists. So if, for example, your contract calls for arbitration in Paris and your counterparty attempts to bring a local court litigation against you in Vietnam, the courts of Vietnam, by agreement under the treaty, should refuse to accept that case, should stay the litigation pending the outcome of the arbitration in France. So if we compare arbitration enforceability, the enforceability of an arbitral award against the enforceability of a court decision, we can see on the right-hand side of this slide an example comparing an arbitral award to an Australian court judgment. And you'll find that similar comparisons apply with respect to a number of jurisdictions. This is just the one that we chose as an example. But so if you have an Australian court judgment and you're looking to enforce it in Asia, you're going to find that it's generally enforceable in New Zealand, Hong Kong, and Singapore, but that it gets progressively more complicated to enforce and reaching very difficult to enforce in most of the other jurisdictions of the region. Whereas, as you can see from the blue color coding on the map of the world on the left, arbitral awards are enforceable in almost all of those jurisdictions. Now, enforceable doesn't mean that it's going to be absolutely painless. There may be situations in which the local courts in the jurisdiction are protectionist or make it difficult or have a very expansive view of a public policy exception to enforcement, or it can be difficult to identify assets against which to enforce. But you don't have the additional legal hurdle of having to convert your court award into something that the local court will recognize, because the New York court does that for you. The New York Convention, I'm sorry, does that for you.